Welcome to It's Time to Get Your You Know What Together. And we are here to discuss everything from estate planning to how to avoid a probate administration, everything in between. But today's topic, I find it near and dear to my heart. It's creditors protection. And we are going to learn so much. So a little housekeeping, please keep yourself on mute. If you'd like to ask a question, you can raise your hand or you can put it in the chat and we'd be happy to address that. Let me introduce to you, without further ado, Samantha Fitzgerald. Samantha, welcome. Samantha is an attorney in Plantation and her firm is 100% focused on estate planning and probate trust administration. She's been practicing for over 20 years. She's a CPA and has her LLM in tax. Please welcome Samantha Fitzgerald.
Hi, everyone. Thanks for coming.
Thank you. And my name is Bianca Moreras. I'll be your host and moderator today. I am a business development and career transition coach and consultant. I bring almost 40 years of experience, oh my gosh, to the table with concentration in law firms and working with attorneys to give them the ability to take their business to the next level. So welcome everyone. We're so happy you're here. So without further ado, we're going to get started with our questions. And some of these questions are real life situations. So we are ready to roll. Can you tell us, Samantha, asset protection seems really, really complicated. Are there any easy options?
So asset protection can be complicated. You know, it's a very broad term, and I think a lot of people use the term and don't really understand what it means. You know, they just know that they don't want to pay their creditors. If it's that type of situation, it's, you know, we're not necessarily talking about, oh, I bought something and I don't want to pay for it. You know, a lot of people think of lawsuits. So asset protection can be complicated and it can be pretty simple. So we're going to talk about a lot of these things, you know, in a little bit more depth, but under Florida law, there's a lot of things that are already automatically protected from creditors that people don't realize. So one big thing that a lot of people are familiar with is homestead, your primary residence. So that's why, you know, OJ moved to Florida. It's a very rare concept. Most states don't have it. We may even be the only state. There might be like one other state. We have a very broad and liberal protection of our primary residence from creditors. So that's huge. You know, you can have there are some limitations, but you can have, you know, a $10 million house. And for the most part, you know, it's protected from creditors. So that's an easy one. Then you've got retirement accounts are protected from creditors. So a lot of people have a lot of their wealth into their retirement accounts. They're protected. Annuities, which are sometimes a crossover with retirement accounts. Sometimes you have like an IRA annuity, but any money that you have in an annuity is protected. College funds, any money you set aside for your kids' college education is protected. Cash value of life insurance. So if you were to buy like a type of a policy that builds cash value, like a whole life or a universal life or something like that, that is that while you're alive, that protection, that the cash value that's built up in there is protected. And tenants by the entirety. So this is a pretty easy method of creditor protection. We've spoken about this specifically in prior Zoominars for married couples only. And it's really simple. If you own an asset as tenants by the entireties, which is a special form of joint ownership for a married couple, it is protected from your individual creditors. So husband and wife own a property, husband defaults on a loan, or husband kills somebody in an accident, husband sued on some sort of business deal, husband gets sued, the asset cannot be taken by the creditor because it's owned jointly by the husband and the wife. Now, if husband and wife enter into a contract, they both default on it, yeah, that they'll be sued and that property can be taken, because that's an example of a joint creditor. So tenants by the entirety is a very, very simplistic form of creditor protection for a married couple only. One big downside to it is when the first spouse dies, you instantly lose that entirety's type of protection. So if there was already a judgment against the surviving spouse and the other spouse dies, your asset's at risk. So, but it is an easy form of protection. So it can be complicated and it can be easy.
Simple. Wow, that was a lot of information.
That was the easy part.
So while we're talking about being sued, what can you do to protect your assets if you are being sued?
Okay. Oh, maybe we should also remind everybody, if they have any questions, they can put them in the chat. You can type them in there, and we can ask as well. So if you've already been sued, or if you know or contemplate being sued because there's an actual creditor or a potential creditor that you're aware of, not just like, oh, well, one day I might be sued. No, like, oh boy, I ran that person over, there's a good chance they're going to sue me. Then your options are limited, really, because we have a law called fraudulent conveyance. So if you transfer your assets in anticipation of a creditor, they can bring them back. So that's not the time to do creditor protection. The time is to do it before. So proper planning in advance is always what, us lawyers like. The things that we just kind of talked about, they're protected though. So if you do get sued, they can't touch any of those assets that you have. Also, if you get, if they try to garnish your wages, so they get a judgment against you, and then they try to garnish your recurring revenue, there are rules about that too, and what they can and can't do. And if you're the main breadwinner in the household, so you're supporting either a dependent or a minor child, they can't take any of your wages, believe it or not. If you're not considered, that's considered head of household. If you're not considered a head of household, then the maximum that they can take is 25% of your wages. So at least they just can't take your entire paycheck. And there are some rules if you are the major breadwinner in the family. But trying to do some planning after you've been sued is challenging.
Sounds like it could be. So does my revocable trust protect my assets from creditors?
Not at all. It is really used as a form of estate planning to avoid probate, to avoid a guardianship for both adults or children, to make sure things pass the way you want them to pass in an easy format without being in front of the court system. It does provide lots of protections for the beneficiaries named in the trust. So it provides creditor protection for them, spousal protection for them, but not for you. So a lot of people think, oh, I have a trust, and most people have a revocable trust, not irrevocable. And it's as if it doesn't exist for creditor purposes, for tax purposes. It's just not that kind of trust. So it's as if you still own the asset yourself.
Okay, well, I do have a question in the chat. All right. If everything one owns is titled in the name of a trust or an IRA, except 20K, example, in a single name bank account, and the person dies, do my kids still need to file probate, and how did the cost work?
So so most of the assets are in a trust or an IRA. So assuming that there's a beneficiary named on the IRA, because that's very relevant. And then there's $20,000 in a bank account. So it also depends if that bank account names a beneficiary or not. So it kind of doesn't matter what kind of account it is, whether it's an IRA, regular checking account, a savings account, none of that matters. It's the beneficiary designation that matters. If there is a beneficiary designation, those assets go directly to that beneficiary, not through probate. If there's no beneficiary on any of those accounts, that specific account will have to go through a probate administration. There's no set fee structure necessarily. Attorneys charge different amounts. We do have kind of like some guidelines in our statutes that some attorneys follow, some attorneys don't follow it. Some attorneys just charge hourly, some attorneys just charge a flat fee. We have different types of probates. So if it's 75,000 or under, you can do a summary administration, which most attorneys charge flat fees for, I think. If it's over 75,000, then it's a formal administration, which is a very, very different process. It's more time consuming, it's costlier. So it just depends.
Okay, great. I hope we answered your question. So while we're on attorneys, can we work with any estate planning attorney to prepare an asset protection trust?
No. So the more complex side of asset protection are these asset protection trusts, which could be based in the US, which are called domestic asset protection trusts, often referred to as DAPs, or foreign asset protection trusts, where you're going to see them in like the Cayman Islands and places like that. Both are complicated. You usually don't see anybody doing them in Florida. You're going to see in, I think it's like, Dakota and Hawaii and Nevada, and there's a couple of states that just have very good debtor protection laws. So it's always going to be an out-of-state trust for us, at least, or a foreign trust. And there's a lot of complexities involved. You need to work with an attorney that does that. You do not want to work with somebody that dabbles in that, or that kind of says that they do that. It has to be their main focus of their practice, because you're getting in a lot of trouble if you do it wrong. And if you do it wrong, you've probably just wasted not only your money, your time, and all your assets are still at risk. So my firm does not do asset protection. We don't hold ourselves out to do that. We know, a lot about it. There's a lot of these basic things that are protected under Florida law, but we don't prepare asset protection trusts. We would refer that to somebody that specializes in it. So just beware when somebody says, oh, I do this, I do this, I do this, I do this, and I do asset protection. No, they don't.
Oh my gosh, good. Thank you. Thank you for that warning. So on another note, I heard that you should form an LLC for rental properties. Does that protect a person?
So LLCs do provide very good creditor protection, but they have limitations. And we did an entire Zoominar on rental real estate. So anybody can go back if you want to see any of our prior Zoominars. They're all recorded. You can, they're on our YouTube page, and you can find our YouTube page from our website. At the top right, you'll see a little link to the YouTube button. So theoretically, yes, LLCs provide creditor protection, because when you put an asset into the LLC, it's the LLC that owns the asset. So if something bad happens to the asset, so rental property is oftentimes, rental real estate oftentimes into an LLC. So if somebody slips and falls, your tenant, hurts themselves on the property, who are they going to sue? They're going to sue the owner of the property, which is the LLC. However, you have to do it properly, and that's where a lot of people get into trouble. You have to follow all of those formalities to the T. And that's, a much longer conversation than today. So if you do everything right, yes, the LLC can provide you lots of protections. Aside from doing things wrong, there's also some downsides to putting it in an LLC. It can be a lot more costlier. The insurance is more expensive. You have to get a separate bank account. If you have a mortgage on the property, forget it. You'll never be able to do it. The lender won't agree. So there's definitely some limitations and drawbacks. Now, the LLC, not only does it provide protection for the asset that you're putting into the LLC, if something happens on that asset, but it also protects the assets that are in there from outside creditors. So this also could be a very complicated discussion, but hopefully a simple example would be, I own a property in an LLC. Well, let's say not even yeah, okay, we'll go with the property example. I own a property, it's a vacation home, let's say, in an LLC. And I kill somebody in a car accident and they sue me and they get a judgment against me and they're trying to take my assets. Well, what can they take? What's available for them to take? We already know they can't take my house. They can't take my retirement account. They can't take my kids' college funds, but I have this vacation home. Can they take it? Maybe, maybe not. So when you have an LLC, they can't just take the LLC and they can't just take the asset that's inside of the LLC. They typically get what's called a charging lien, meaning that they can attach any of the cash coming out of the LLC, so the distributions. So that's where it gets a little gray. You know, are there distributions coming out? Is the creditor going to be satisfied? And that's where it gets a little bit more complicated. So LLCs can all provide protection to the outside creditor. So it has a double layer of protection, but the analysis gets complicated and it depends. So that's always a discussion you should have with your attorney, but they can provide great protection, but sometimes misguided. People think they have more protection than they really do if they're not doing things right.
Oh, gosh. So, you know, you hear all these stories, how great that is, and you just scared the bejeebas out of me. Okay. So I'm going to give you a little scenario here. Say my husband died and he had a lot of debt and he had a final paycheck coming to him from his employer. Can his creditors take that paycheck?
Nope. It will be paid directly to the spouse or the children.
Okay, good. That's good to know. Don't tell Steve, don't tell my husband anything, God forbid. I'm disabled. What if someone is disabled and receiving disability benefits under, you know, a private disability policy? Can their creditor, or my creditors or their creditors touch their income?
No, it's protected.
All right, that's another good one. Yes. And, you know, getting back to IRAs, if someone inherits an IRA from a relative, a brother, a cousin, can their creditors take away that money, his creditors, if he has debt?
In Florida, no. So this is a really interesting topic. So IRAs and other retirement accounts have lots of creditor protection. So I'm alive, I have a retirement account, it's protected from my creditors while I'm alive. I die, I leave that IRA to my spouse or my children or whomever, doesn't matter who. Under Florida law, an inherited IRA is protected from the beneficiary's creditors. Now, that same rule may not apply if the beneficiary lives in a different state, because not all states have that. This is a state rule, which is one reason why I like to flow the retirement benefits through my client's trust, where I know it will be protected, because I don't know where the beneficiary is going to be living at the time of my client's death, and it may or may not be protected. There's other reasons why I do it too, but that's one of them. So if the beneficiary lives in Florida, the beneficiary has a bunch of debt when I die, yes, that IRA is protected from them, from their creditors. Now, a little twist to that, if I don't have a beneficiary on my account, so let's say I have a will that says who my beneficiaries are, right? But I don't have a beneficiary on the actual IRA. So it gets paid to my estate, but then it passes to my beneficiary under my will. Nope. Now it's subject to my creditors. And I'm pretty sure, I'm not 100% sure, but I'm pretty sure, yeah, I am sure. It's also going to be subject to the beneficiary's creditors. It just completely lost all of its creditor protection on both sides. The same is true for life insurance proceeds. If life insurance proceeds, I die, my husband receives he's the beneficiary of my life insurance, or my kids are the beneficiary of my life insurance, or my brother or sister or whomever, it doesn't matter. If I have debt, it's protected. It doesn't pass through my estate, so my creditors don't get paid. If they have debt, that's a little different. If they have debt, it doesn't have the same protection as an IRA would have. But if I have no beneficiary on that policy and those same proceeds get paid to my estate and I have debt, I die with debt, the creditors are going to take those life insurance proceeds. So it's very, very important to make sure you have some sort of designated beneficiary on life insurance, annuities, retirement accounts, because those things are all creditor protected until they get paid to your estate, to the probate administration, in which case then they lose all protections.
Wow. Just, that could just be a mistake that people make. So, wow.
A mistake. It can be where we see it a lot is where somebody has one named beneficiary, their spouse or their brother or their sister or their mom or dad, whatever, and they don't have contingent alternate beneficiaries. And then, people, they get policies, they open accounts and they do this and they never look back. Life goes on. People die. So if your named beneficiary predeceases you, it's as if you have no beneficiary.
Wow. Okay. Well, what if it goes into your estate and you do have, and you die, of course, and your kids are in the estate? It's still subject to your creditors first?
When we're using the term estate, we're talking about probate.
Okay.
So if it's payable to the probate estate, yes, it's available to all of your creditors. If it passes into your trust, then no, it's still exempt.
Good. It's the terminology that will get you, Samantha.
Yeah.
That's why we have you. And I have one last question. I'm the personal representative in an estate, and the decedent had a lot of creditors. Are any of the estate assets protected? And I think you might have answered that, but.
Absolutely. So the homestead, that's a huge one. Even if that passes through a probate administration, if it's your homestead and it passes to your heirs, then it is going to be protected from the decedent's creditors. There are some limitations for homestead. So if it's within a municipality, only a half an acre plus the structure is protected. So if you're sitting on an acre of property someplace in Southwest Ranches or, Plantation Acres, then a piece of it is going to be available for creditors, and that gets really complicated. If you're outside a municipality, it's 160 acres. So those are the limitations on that. It does have to pass to your heirs, so it cannot pass to a boyfriend or girlfriend or a friend or anything like that. It could pass to stepchildren, which do qualify as heirs as well. But so there are limitations there. 2 cars are exempt as long as you have a spouse or children. Up to $18,000, something we call family allowance. So if you were supporting, a spouse or children, they can kind of pull out some money off the top, so they have a little bit of money to live on. It's not a lot, but it's something. And then $21,000 of personal effects. So there's $20,000 under the statutes and $1,000 under our Constitution. So all of those things are exempt from creditors. Anything above that would be available.
Well, I guess we were just so informative, Samantha, that there's no questions. But, we always like to thank you for coming and let you know, number one, as Samantha said, she has all the recordings on her website on YouTube. And we've done, oh my gosh, I think about 15 of these already, if not more. I don't even know. And, there's always that information. There's always pick up the phone. She'd love to speak to you and answer a question and see how we can help you. She is very knowledgeable and she is super awesome, on fire always. She's a brilliant young lady. So again, we want to thank you for coming. This program occurs the third Friday of every single month at 12 o'clock. And we'd love to have you. Keep your eye out for our communication. And we thank you for coming, and we're happy to see you next time. Sam, would you like to say it last few words?
No, thank you everybody for coming. It was great. We love having you all here. If anybody has a topic they want us to address, feel free to email us. I'm happy to take a look at that. And as I think Bianca mentioned, if you missed any prior ones, or I said earlier too, you can check them out on our YouTube page. They're all just a half an hour. So we're in and out 12 to 12:30, third Friday of every month. And thanks again for coming. We'll see you in February.
Awesome. Thanks, everybody. Have a great weekend.